Hey, good afternoon. Welcome back to our program. This is another video in our series where we discuss everyday legal issues with TLR Law. TLR Law is your neighborhood law office here in Winnipeg with 2 law offices for TLR Law and a new 3rd office for Estate Attorneys of Manitoba on Sargent. I'll give you the addresses at the end of this video, or you can go to tlrlaw.ca for those contacts. Today we're talking about employee contracts. They can save employers and employees a lot of heartache and trouble, but a surprising few number of companies actually use them. My name's Adam Dooley. I'm your co-host today along with Philippe Richer. He's the principal lawyer and owner of TLR Law Office. Philippe, it looks like we both had our pandemic hair trimmed. I'm back in the office thanks to relaxed restrictions. How are you doing?
I'm good, and I agree. The haircut allows me to show myself in public now, so I'm happy to also be back in front of clients and at the office.
Yeah, I'm using less product now because it's a little bit less unruly. So let's get into today's topic, employee contracts. When you're working with corporate clients, I know you and I have talked about this in the past, you always bring up the subject of employee contracts. Why is that? Why are they so important?
Well, employee contracts affect every single business where there's an employee. Employee contracts, the problems associated with them will affect all of the businesses, from the small sole operator, sole proprietor who's hiring somebody on a part-time basis, all the way up to the big corporations that employ thousands of people. There is a lot of liability that goes with them because the Supreme Court of Canada has established that all employment relationships are contractual in nature. So if you don't have a written contract that clearly sets out what the terms of that contract are, the court will infer a bunch of conditions, and they're usually in favor of the employees, and they can cost an employer a significant amount of money. So it can be very costly for a business owner if they don't have one in place.
Now, when we're talking about costly, these are not insignificant severance packages that are potential, right?
No, not insignificant at all. It could be. I've seen cases where, now granted, this is with senior employees that are paid a lot of money, but
Yeah.
I've seen cases that had payouts in the hundreds of thousands of dollars. So if you're
Wow.
a small business, those can easily be $20,000, $30,000 in payments. And I don't know about you, but I run a small business. But a small business as well. Sorry.
It's okay.
Working from home today. I run a small business as well, and if I had to pay $20,000 or $30,000 or $50,000, that would take a big chunk out of our retained earnings.
Part of the dog's contract says he's allowed to interrupt. That's perfectly cool.
Yeah.
So no, you're absolutely right. That kind of cost would really be painful for most small businesses. But let's talk about that. Like, why do those costs exist? Just a review. We're talking about dismissals and severance packages, right?
Right. So there's two ways to dismiss somebody. You can dismiss somebody for cause, so that's I have reason to do it. So somebody steals from you, for example, you can dismiss them. There's a few problems associated with that, which I'll touch briefly on. And then there's dismissal without cause. So dismissal without cause can be for a number of reasons. Could be that you need to do layoffs, you need to restructure because you're, in COVID, for example, when it all started, a lot of companies, restaurants in particular, had to lay off staff. Mm-hmm. That's laying off without cause, and there are repercussions to that. So it comes. The problem for business owners, that the cost comes from when they dismiss people without cause. There's this concept at law where you have to give somebody a reasonable amount of notice when you terminate them.
Right.
And that reasonable amount of notice will increase with the amount of time that an employee has at the business and their age. And there's a bunch of factors that are taken into account: their education level, their role, how easy it is for them to find new employment afterwards. And that's separate from the labor code, which is a law that's on the books in Manitoba, which also lays out a minimum amount of what those severance payments are. And so you have to pay the severance payments that are listed in the code. And if you don't have a contract, then you have to take into consideration these other factors that I talked about. And somebody could be entitled up to anywhere from 2 to 4 weeks of salary for every year that they've worked for you.
Right. So if you have a
So it's
long-term
easy.
employee who's been with you for 10 or 20 years, that can be a significant hit.
Well, so let's take that example. Let's say you have, you're a small business and you have like an office manager, for example, that makes $50,000 a year, and that office manager has been with you for 15 years. Due to growing business, maybe the office manager isn't really adapting to the new reality, and it's time to make a change. Well, if you don't have a contract in place that limits that liability, then that office manager that's been with you 15 years, let's say he's 50 years old and maybe doesn't have much of an education, you may have to pay 3 weeks of severance for every year that he works for you. So 3 times 15, that's 45. So 45 weeks.
It's almost a full year.
When you consider that's almost a full year's salary. So you're looking at close to $40,000 in severance that you have to pay that person.
Yeah.
I can't afford that myself.
Yeah. So how do employee contracts resolve this for companies?
So in the contract, and the courts have agreed to this, that two parties are allowed to come to a decision together. So in your initial contract, when you hire them, and this is really important, it's at the time you hire them that you can enter into a contract. Once they start working for you, you cannot just unilaterally impose a contract on them.
Okay.
So once they start working for you, before they start working for you, you enter into a contract, and in the contract you can agree that the only severance you have to pay is the severance that you're required to pay under the labor code. So you can't opt out of that severance. That's the basic law in Manitoba. The labor code has a little grid in there that shows what your severance is. After 1 year or up to 1 year, you're entitled to 1 week. 2 to 3 or 4 years, I can't remember, you're entitled to 2 weeks. And it goes up to somebody with 10 years or more, they're entitled to 8 weeks. You can't opt out of that. You have to pay that out regardless.
Right, that's statutory,
But you can
that's in the law.
That's the basic, that's the floor. You can't go below that floor.
Right.
But anything above that, the common law, the law that the judges have developed, where all of these, the 2 to 4 weeks severance comes in for every year of employment, that you can opt out of that in the contract. You can say that law that the judges have determined is not applicable because we're two parties that we're agreeing right now that that's not applicable. We are limiting our exposure, and you're okay with that. To what's in the statute, which is the labor code.
Right, and
so that's how you can save yourself like a big chunk of change.
And to be clear, we're not talking about creating contracts to be unfair to employees. It's about making sure that this is a sustainable situation for the business, because these severance packages can in fact sometimes prevent a business from moving on or making a necessary change, or if business falls off and they have to let someone go, this could actually end the company.
Right. The risk here for the business owner is it can put you out of business. Right, because they take you to court and the judge grants an order for $50,000. You have to pay that money over.
Right.
If you don't have the money over, guess what? You're closing the shop.
Yeah.
So it's about rebalancing what the courts have done by favoring the employees. It's about rebalancing that between the employer and the employee to something that they can both live with.
Right, something that's fair for both of them, right?
Right. You can agree to something different. You can agree to, in addition to what's in the code, you can agree to pay a 1 week for every year that they work for you. You can do that as well, as long as it's in the contract. The courts are going to say, you have a contract, it's written, it's clear, we're staying out of this.
Right, makes sense. So there's other things that can go into employee contracts too. Things like a non-compete clause or a non-solicit agreement. Can you work those things into contracts as well?
You can, but they're tricky, especially in employment type situations. Courts do not like enforcing non-competition agreements when it prevents somebody from earning a living, right? It goes against public policy. If you're a pilot and you work for Air Canada and you sign a contract that says you can't fly planes for anybody else for a period of 5 years after the end of your contract, guess what? You're unemployed for 5
Yeah,
years.
that's unfair. Yeah.
Right, and the courts will not enforce those. So they're very limited in scope. It's a maximum of 6 months, really, and it has to be very, very narrow. And in those types of provisions, what a court will do is if they find that the employer overreached, they will just declare the whole contract invalid.
Right.
Like they'll take the whole contract that you had and toss it, including all the limitations on notice provisions. So that means that you did all this work to limit your liability in terms of notice, and then just by being careless or overreaching with the non-competes clause, you render the entire contract invalid. So you got to be really careful with that.
Right.
A much better way of approaching that is through the non-solicit clause.
Okay.
Which courts have enforced more generously. But again, they also take a pretty close look at that. If the non-solicit clause has to apply to people that the employee has actually had contact with, not the entire company's customers.
Right.
So they would strike out something. If it's a sales rep, for example, you have to limit it to the clients or customers that the sales rep has serviced. Other customers that never dealt with that sales rep, you can't include those in your non-solicit, because the court again they're looking for ways to invalidate those. So you have to be very careful.
So your recommendation for companies is you should be setting these things up within the hiring process. This should be part of your HR hiring process. Is that how you look at it?
Yes. So when you're making an offer of employment, you should make the offer of employment with the contract. So you would make if you do it by a letter, you would do the letter. If you do it by email, you'd say, we're offering you a job. Here's the contract. If it's in person, you would give them the contract and you'd give them a chance to review it and sign it.
Right, that makes sense. So why do so few companies do this? It seems like it's almost a secret that they don't even know that this is available to them as a possible tool.
I am continuously astounded by that. Charlie Munger, it's on my website. I've said it before. The whole job of being a successful entrepreneur is to not be stupid.
Right.
This is an area where a lot of employers are stupid. I have no explanation for it. There is a ton of case law. There are lawyers who practice in the area of employment law. This is how they make their living. They represent people that have been terminated without cause, that have not been paid sufficient severance, and there's an entire professional industry that exists because of this, and yet small business owners never turn their mind to this, and they essentially have this huge liability on their books that they don't even know about.
Yeah, it's amazing. So what's your recommendation on how a small business should get started with using employee contracts? They've already got a batch of employees. You've already said they can't really impose contracts after the fact. What's the best way for them to get started?
So the best way is to not be stupid from the beginning and to just get employment contracts. Talk to a lawyer. Spend the $300 to even $1,000 to get a contract drafted. These contracts are very similar, so you probably just need your lawyer to prepare one contract for you. Mm-hmm. And for all people that are in similar kind of positions, that contract would probably work for all of them. So you don't need to pay the lawyer every time you hire a new person. You could have something that will likely do the trick. If you have more senior people, then your employment contract will be more complicated, but that's all right. Spend the money up front. Because a more senior person costs you more money, and it'll upfront in salary, and will cost you more money if you don't have a proper employment agreement in place.
Yeah.
So that's the best way to do it. If you already have staff if you have a large staff that you don't have contracts with, there is a way where you can negotiate contracts for those who are willing to do it. I won't get into the details right now. Just call us or call your lawyer to figure that out. But there are ways that you can get a staff that are currently employed on contract, and to have that contract stand up under judicial scrutiny. But you have to do that carefully as well. You can't, if you put it this way, if you show up to somebody who's been working for you for a number of years and you give them a contract and you say, here, sign this, the court is going to interpret that as constructive dismissal if the person quits.
Right.
And maybe back up. I don't want to get too much in constructive dismissal, but they're going to say the court will take the position that contract was not a valid contract because the employee, what are they going to do? Say no and lose their job?
Right.
They don't want that to happen. And courts understand that. So they're not going to recognize a contract that is imposed like that. So if you just do that, then you're being stupid.
Okay, well,
So don't.
we don't.
So be not stupid.
We don't want to be stupid. But let's talk about employees because they don't always stay in the same position. Jobs can change. They
Right.
can get promoted. They can change duties significantly as they rise through the ranks. How do you review or change contracts over the years, or can you?
This is the beauty of employment contracts, is that you don't once you get them in the door as a frontline baseline worker. Let's say you hire somebody who's 18 and they're sweeping the floor in the shop, and you get them to sign a contract, and that person stays with you for 40 years and becomes an operations manager or even the general manager. That initial contract, if it limited the ability to, or limited the obligation to give notice, will follow the employee all the way through their career.
Really?
So, yeah.
So
You don't need to update.
So new duties and responsibilities or new clauses. Would you ever renegotiate a contract or
You can, but I mean, I can't really think of a situation where you'd have to at this point.
Right.
But you can. I mean, and maybe you want more protections, maybe more specific items if they're going to become, the C-suite employee. Like if they start off as a janitor and now all of a sudden they're an executive level, you may want to, at that point, you may want to impose some non-solicits, which you didn't consider at the beginning, or you may want to impose some non-competes, which you didn't consider at the beginning. So at that point, you'd want to renegotiate the contract.
Right, and those non-compete clauses are really only for the executives, right? The senior.
Yeah, you have to be really careful. You have to be really careful with the non-competes. Yeah. Too many employers take too broad a view on that.
Right.
And it's part of owning a business. When you own a business, you kind of feel entitled to your business, and you want, well, it's crap. I don't want my employees going off to the competitor. And I certainly see that point of view. But what they fail to see is the other side of the coin, the employees' rights, and even worse, what a judge will look at. And I can tell you, judges don't particularly care about your business.
No.
Not at all, in fact.
No, that's true enough. Well, thank you very much, Philippe. I think it's a fascinating discussion, and I hope that more small and mid-sized businesses take you up on your advice and give you a call or speak to their own lawyers about getting employee contracts.
Yeah.
If you're looking for more information and you would like to talk to Philippe or one of the other lawyers at TLR Law, you can reach out through tlrlaw.ca. We're all over social media as well, Facebook, Instagram, LinkedIn, and YouTube. You can search for us just using the tag @TLRLaw, and you should be able to find us on all of those. There are 3 offices now with TLR Law. Congratulations on your growth, Philippe. You've got your headquarters on Provencher at the base of the bridge. You've got Pembina South at Markham Road, and your latest office is Estate Attorneys of Manitoba on Sargent. You've been growing quickly.
Yes, I need to get my head checked.
Well, thank you very much, and thanks for tuning in. We'll see you next time.
Sounds good. Thanks, Adam.